What's up? Hi guys. How you guys doing? I know there's a few of us here. We're gonna get right into business. What's up? I hope you guys are having a good day. We're gonna be reviewing the new complaint from Diddy. You know, we've been reviewing them here on my channel. I like to review these legal documents. So this one is from the 15th, and it was filed by someone named Ashley Parham. It's pretty long, but I had already gone through it kind of and shortened it. So, let's see who's here. I see Debbie. Hi, Debbie. Thank you for stopping by. Jojo and others who are here that I know are just hanging out and watching. Let's see. Oh, let me pull up the document so you guys can see. This one is wild, trigger warning, language, events happening in this. It's a little brutal. Let me make sure. Okay, you guys can see it. Again, this was filed on the 15th, the new complaint against Diddy by plaintiff Ashley Parham. Trigger warning. Okay, page 1. Plaintiff Ashley files her complaint against defendant Sean Combs, Christina Coram, which she goes by KK in the document, Shane Pierce, John Doe's 1 through 3, and Jane Doe. Let me turn the page for you guys. Okay, so the introduction. This case involves sexual assault, battery, RAPE, SA abuse, false imprisonment, and kidnapping. Defendant Diddy has always been sued by countless individuals for crimes similar to the ones enumerated in this complaint. Defendant Diddy is currently a federal inmate awaiting criminal trial for crimes similar to the ones enumerated in this complaint. Defendant KK is an employee of Defendant Diddy, often referred to by Defendant Diddy as his right-hand woman. Defendant Diddy's predator behavior was constant and was well known by several individuals, including Defendant Diddy's employees, staff, friends, family, and associates. In fact, Defendant Diddy's sons are being sued for engaging in the same type of deviant behavior as their father, as pled in a Los Angeles Superior Court filing. Whoa. Defendant Diddy was able to effectuate his crimes and evade capture and prosecution for his crimes for almost 30 years due to his position of power and influence in the entertainment industry. Defendant Diddy exploited his position and his relationships with powerful individuals to force sex acts through exploitation, fear, manipulation, physical threats, emotional abuse, intimidation, and retaliation. Had any of the previous crimes of Defendant Diddy had been taken seriously, or any of the abettors like defendants KK, Shane, Doe's 1 through 3, or Jane Doe reported Defendant Diddy's actions to law enforcement, Defendant Diddy's illegal and unfathomable behavior could have been prevented. Instead, Defendant Diddy was able to rain his abuse and terrorism on countless victims for over 30 years. Additionally, had Defendant Diddy's numerous business partners and associates not ignored Defendant Diddy's deviant behavior, Defendant Diddy would have been unable to continue his pattern of abuse over such a long period of time. As alleged herein, Defendant Diddy abused his position of power in the entertainment industry to garner loyalty and trust from the public at large and law enforcement while instilling fear and intimidation into the hearts of his voluminous victims. Well, yeah, allegations against Defendant Diddy have been disregarded for decades, therefore creating a failure to protect victims like the plaintiff named herein. Unlike most victims of Defendant Diddy who were employees, SEX workers, or individuals seeking out defendant to help launch their careers, plaintiff does not fall into any of these categories. Plaintiff met Defendant Diddy due to happenstance and still ended up being brutally victimized in a similar manner as described by others who have preceded her filing and others who surely will follow after her filing. Due to defendants' agreements to participate in corrupt enterprise, plaintiff and countless other victims have been immeasurably and permanently harmed. Plaintiff alleges as follows upon personal knowledge as to themselves and their own acts and experience, and as to all other matters upon information and belief, including investigations conducted by their attorneys. Parties involved. So the plaintiff is Ashley Parham, and she's an individual who resides in and is domiciled in California. Defendant Sean Combs is an individual who resides in California, owns a residence in Florida. Defendant Christina Coram, known as KK, is an individual who, upon information and belief, resides in and is in California. Defendant Shane Pierce is an individual who resides also in California. John Does 1 through 3 are individuals who, upon information and belief, are also residing in California. And then there's defendant Jane Doe, also resides in California. Next page. The court has personal jurisdiction over all defendants because they have purposely availed themselves, are residents of the state and or were conducting business in California, and this lawsuit arises out of acts that occurred in California and relates to their contacts with California. Further, the pervasive culture of abuse, including SA, RAPE, inappropriate touching, and wielding power and control over plaintiff, was a constant presence when defendant Diddy and the other herein named defendants engage in the acts described herein. The location of all events herein alleged occurred within the jurisdiction of California. Plaintiff was harmed and injured in California by defendants. This action is timely under the RICO Act, as the Diddy SA abuse enterprise fraudulently concealed the ongoing SCX and deceitful activities towards conspiracy taking place. This action is also timely under California's SA and Cover-Up Accountability Act, which is an act that extends the statute of limitations, opening up revival windows for adult survivals of SA assault and related claims, and acknowledging that a 2-year statute of limitations simply does not provide SA survivors adequate time to heal from their physical and emotional trauma of SA and prepare for a civil case. Okay, let's get to the factual allegations. Let me make sure I'm on the right page. Plaintiff met defendant Shane in February 2018 after an altercation with another man at a bar, and defendant Shane came to plaintiff's rescue. While outside the bar with friends and other patrons, defendant Shane FaceTime video called defendant Diddy and was showing people defendant Diddy in the video on his phone, attempting to impress the people with his famous friend. Defendant Shane then showed plaintiff defendant Diddy on his video call, which plaintiff ignored, stating that she was not impressed by him knowing defendant Diddy because she believed defendant Diddy had something to do with the unaliving of rapper Tupac Shakur. This is wild. Hi, Johnny. Thanks for being here. Appreciate you. Visible in the FaceTime call was Diddy and some of his children, including his sons, Christian and Quincy. It appeared from the plaintiff's perspective, defendant Diddy was having a get-together at his home during the time of the FaceTime call with defendant Shane. Defendant Diddy heard plaintiff's statement and made a remark that plaintiff would, quote-unquote, pay for her statement regarding Tupac and overall dismissal of defendant Diddy. On March 23, 2018, defendant Shane invited plaintiff over to his home to assist him with his cancer medications because he stated he was weak and unable to open his medications. Upon plaintiff's arrival, defendant Shane informed plaintiff that he wanted to give her a ride in his new car. Plaintiff and defendant Shane left his residence for a brief period and then returned. Once they returned, defendant Shane left the door to his apartment partially open and stated that the door was ajar because there was an issue with the door where it couldn't close completely. Defendant Shane was renting an apartment on the lower floor of a home in Orinda, California. Shane had a separate entrance into his residence that led to the backyard of the home. The home also had a main entrance on Loma Vista Drive. Shane returned the home rented the home from a woman who lived in the upstairs portion of the home and had 2 dogs who resided with her. Plaintiff and defendant Shane then began to watch a movie, and defendant Shane offered her a glass of water, which he retrieved and brought back to plaintiff. Approximately 10 minutes after plaintiff and defendant Shane returned from their drive, Diddy entered Shane's residence. Diddy entered the home in a grand, quote-unquote, ready-to-party manner. His grandiose entrance was so loud that the dogs upstairs began barking. Defendant Diddy did not enter the home through the backyard entrance, but instead through the main entrance. Hey, TS, good to see you. Thanks for being here. Along with the defendant, Diddy were his bodyguard, defendant Doe 1, a woman who plaintiff later identified as defendant KK, another woman, small, skinny build, early 30s with blonde mid-length hair, whose plaintiff has still been unable to identify. Jane Doe, defendant 2, who upon information and belief is a friend of the defendant Shane, and Diddy. Also Diddy's driver, Doe 3, who remained outside and in his vehicle during the duration of the plaintiff's assault. Plaintiff, Ashley, believes defendant Shane invited her over to set her up to be assaulted by defendant Diddy because of the statement she made about Diddy a month prior. Upon Diddy's arrival, he immediately began to antagonize the plaintiff, stating that she would never see him in person, quote unquote, pay for her statements about Tupac during the video call, and that defendant Diddy caught plaintiff. Plaintiff was in shock as she never believed she would ever see or meet defendant Diddy in real life, let alone in a small apartment rented by defendant Shane. Diddy then began advancing towards her where plaintiff was sitting on Shane's bed with a knife and held it to the right side of plaintiff's face and threatened to give her a glass glow smile in retaliation for her previous statements on the video call. Wow. Defendant KK told defendant Diddy that she did not think giving plaintiff a glass glow smile would be advantage to their potential clients, who they could, quote unquote, sell plaintiff for sex to. Defendant KK then made a threat to plaintiff that they would ship her off anywhere in the world and that she would never see her family or anyone she knew ever again. Defendant Shane then partially undressed plaintiff. Then defendant Diddy removed the remainder of plaintiff's clothing, removing the knife from her face, and then retrieved a bottle of liquid from a large fanny pack. Defendant Diddy then squirted a bottle of liquid on plaintiff, which placed her in fear that she was being squirted with a chemical substance like acid. Plaintiff soon realized the substance was an oil lubricant. Plaintiff was squirted with this liquid substance over the entirety of her naked body. Defendant KK was then told by defendant Diddy to insert what looked like a syringe from sterile packaging into plaintiff's lower area. Defendant KK did as told, and then told defendant Diddy that she was unable to use the IUD because it had prematurely been released from its packaging. Defendant Diddy, upset by this, took the syringe from the defendant KK and tried inserting it into plaintiff's lower area instead. Defendant KK and Diddy began to argue as defendant KK continued to advise defendant Diddy that since the IUD had been prematurely released from its packaging, there was no way they could insert it into her effectively. After some time, defendant Diddy heeded the advice of the defendant KK and removed the syringe from the plaintiff's lower area and handed it to defendant KK. Whoa, this is brutal. Sorry guys, trigger warning. That's why I said that at the beginning. Hey, crime to remember, I appreciate you for being here. Yes, he does, crime to remember. He does all of those names. Diddy, Love, all of that. Yeah, this is what? Defendants, let me continue. Defendants KK and Jane Doe then exited defendant Shane's residence, leaving plaintiff alone with Diddy, Shane, Does 1 and 2. Defendant Diddy then picked up a television remote that was near plaintiff and violently inserted it into plaintiff's lower area. Defendant Diddy, while violently assaulting plaintiff with a television remote, told plaintiff that her life was in his hands and that if he wanted, he could take her and she would never be seen again. Plaintiff began hysterically crying from the threats by defendant Diddy, along with the pain of being violently assaulted by defendant Diddy with the television remote, as well as the lingering pain from the ordeal with the IUD syringe insertion. Ugh, this is brutal. Defendant Diddy then instructed defendant Shane to turn plaintiff on her stomach, seemingly tired of hearing the plaintiff's blood-curdling cries. Defendant Shane then grabbed plaintiff by her abdomen and hips and turned plaintiff on her stomach. Defendant Diddy then instructed Shane to put a pillow over her head because he didn't want her to see her face or hear her cries, and instructed defendant Shane to 𝐴NALLYRAPE plaintiff. Oh my God. If this is true, whoa. Sorry, guys. We're going over the complaint, the recent one on 10/15, Ashley Parham against Diddy. Oh, I don't know about that, crime to remember. It does say it at the top, though. Like, it says, like, plaintiff and her name, and then it says, like, all of his names. So I'm not sure what that means, to be honest with you. Defendant Shane did as he was told by defendant Diddy and began to assault her. And Diddy then began to, you can see that on the screen. Defendant Diddy then assaulted plaintiff after defendant Shane. Defendant Doe 2 then joined defendants Diddy and Shane, taking a turn assaulting her as well in the same manner. Immediately after defendant Doe 2 assaults plaintiff, he exited defendant Shane's residence. Diddy then instructed defendant Doe 1 to also assault plaintiff. Instead of immediately assaulting plaintiff, defendant Doe 1 doused plaintiff with more oil and lubricant and then jumped on top of plaintiff's naked and oiled body, treating it like a slip and slide and knocking the wind out of plaintiff due to his enormous size. Defendant Doe then caught himself from sliding over plaintiff's oiled body and off the bed. He then began assaulting plaintiff again. While defendant Doe was assaulting plaintiff, defendant Diddy sat in a chair near the bed and began touching himself while recording plaintiff's assault by defendant Doe 1. I don't know. This is brutal. Another party's phone fell on the bed near plaintiff. Plaintiff then attempted to grab the phone, but it slipped out of her hands and onto the floor due to the oil lubricant that had been doused all over her person by defendants Diddy and Doe 1. Defendant Diddy began laughing at plaintiff's attempt to grab the phone. Throughout this violent assault-style rape, defendant Diddy made a constant belittling remarks to plaintiff, including that he owned her now. Plaintiff's body was becoming more and more limp over the course of the violent attack until she had no control over her body, nor could she move her body. When defendant Doe finished assaulting plaintiff, defendant KK entered the room to examine the condition of plaintiff, who was barely able to move or control her bodily functions. Defendant KK examined plaintiff to see if she needed his assistance and was about to give plaintiff an IV fluid. Plaintiff could not be certain if she did or did not receive such intravenous intervention. Defendant KK then opened a different bag, different than the one defendant Diddy removed the oil from, where plaintiff observed several medicine bottles, IV fluid bags, and unidentifiable powder-like substances. Defendant KK then removed a pill from one of the medicine bottles and gave it to defendant Diddy. Defendant Diddy then inserted the pill into plaintiff's mouth and down her throat to where plaintiff had no choice but to ingest the unknown pill. Defendants Diddy, Shane, KK, and Doe 1 then exited the residence to the backyard where they smoked marijuana and cigarettes. Plaintiff remained in an almost lifestyle state in defendant Shane's bedroom until she finally regained her bodily functions. Plaintiff then began looking for her clothes in her purse that contained her car keys and cell phone, but could not discover them in her room or anywhere in the apartment. Plaintiff was only able to find a t-shirt on the floor, which she put on her body. Plaintiff also observed a black condom wrapper on the floor of the bedroom which she assumed was used by one of the defendants, most likely Diddy. Plaintiff then grabbed a knife from the kitchen and headed to the backyard where the defendants were smoking, as that was the only way to exit the premises onto the street. Plaintiff concealed the knife on her left side as she exited the apartment to the backyard area. Upon coming to the exit of the home, which led to the backyard, plaintiff was met by defendant Doe, who was standing at the door between the residence and the backyard. By the time plaintiff was able to compose herself and come to the backyard, defendant 𝐾𝐾 was no longer in the backyard but upstairs on the patio balcony with defendant Jane Doe. Defendant Doe allowed plaintiff to walk to the backyard where defendants Shane and Diddy were still smoking. Can you guys see this? Okay, I just want to make sure you guys can see it. I know. I feel like this one is kind of brutal. Crime to remember. Defendant Doe did not see the knife that plaintiff concealed on her left side as it was obstructed by the oversized t-shirt plaintiff was wearing. Plaintiffs observed defendant Diddy still partially not wearing any clothing from the assault, while defendants Shane and Doe 1 still had on their clothing. Defendant Shane then left the upstairs portion of the patio balcony where defendants 𝐾𝐾 and Jane Doe were already situated. Plaintiff then sat down on the makeshift seat in the backyard when Diddy noticed her presence and remarked that he was surprised she was able to walk because he had given her enough drugs to take out a horse. Plaintiff then asked defendant Diddy what he gave her, and he laughed and did not provide a response. Diddy then made further comments to plaintiff in a jovial, friendly manner, asking her why they hadn't partied together before because it was so much fun and he hadn't had any ASS that tight in a while. Defendant Doe then quipped at defendant Diddy that he probably hadn't had any of that because he's not used to having blank with women, which defendant Diddy and Doe 1 laughed at. Plaintiff then told defendant Diddy she did not party with him and she did not enjoy partying with him and that he had attacked her. Oh, I see what you're saying. A crime to remember. I see. Defendant Diddy did not like plaintiff's response to his lighthearted commentary and offered plaintiff money and instructed plaintiff to say that the assault was consensual and that plaintiff was an sex worker. Plaintiff became enraged and yelled at defendant Diddy that her attack was not consensual. She was not a sex worker and she refused to take any money from him and would tell the police that. Defendant Diddy then told plaintiff no one ever believed she had been attacked by him, and if she did tell anyone such that they would harm her family. Defendant Doe then showed plaintiff his phone, which looked as if it was the outside of plaintiff's estranged sister's residence, as she could see her sister sitting on the couch and her sister's spouse on the balcony. It looked as if someone was outside the residence streaming the video to defendant Doe 1's phone. Wow, if that's true, right, Carrie? Animals. Plaintiff, while rattled by what she was seeing on defendant Doe 1's phone, was still angry about being attacked and was not complying with Diddy's request to take the money being offered to say that it was consensual. Defendant Diddy then called his mother in an effort to further convince plaintiff not to report it. Is this true? What are you guys thinking right now? This is wild. He called his mom to convince her. This is all alleged. This is just a new complaint. He is, I guess, innocent until proven guilty. We already know what's going on with the case. I am not a legal representative. We're just reading the legal court document provided to the public. So I just want to make that disclaimer, but this is wild. Defendant Diddy's mother yelled at plaintiff to not hurt her son. Plaintiff told defendant Diddy's mother that her son had attacked her. Defendant Diddy's mother, seemingly unfazed by the statement, then continued her demands to take the money being offered and not report it to law enforcement. Okay. Defendant Diddy then made further threats that he had gotten off from bigger crimes than this and referred to Tupac again, further antagonizing plaintiff. Defendant Doe 1 then turned to Defendant Diddy and pulled his GUN on him, asking him to repeat what he said in reference to Tupac. As the two of them were exchanging words, plaintiff went behind Defendant Doe 1, where he seemingly began to protect plaintiff. Defendant Doe 1 then advanced to Defendant Diddy, questioning him over the comments he had made about Tupac. During this commotion, a neighbor directly across the street came outside and peered into the backyard and asked what was all the commotion about. Defendant Doe then pointed the GUN at the neighbor and instructed him to mind his business and return to his residence. Defendant Doe 1 then turned the GUN back on Defendant Diddy. Plaintiff, not far from the Defendant Doe 1, tried to grab Defendant Doe 1's hand at the GUN. The GUN then went off and hit a hill behind Defendant Shane's residence. Diddy then ran up the back stone stairs near the hill in the backyard towards where defendants KK, Shane, and Jane Doe were. Plaintiff charged towards Defendant Diddy, moving the concealed 𝐂𝐻𝐸 from her left hand to her right hand and in pursuit of Diddy. Plaintiff then pushed Defendant Diddy from behind while on the stone stairs outside, causing him to fall on his back to plaintiff. Plaintiff then raised the weapon in a rage from the events that had just transpired, and with the intent of driving the weapon into Defendant Diddy's back when he turned around and began pleading for his life. Plaintiff, shocked now to see Defendant Diddy acting as a victim, had a moment of clarity and then turned and ran down the outdoor stone staircase back out to the backyard to escape. Defendant Diddy then chased plaintiff down the stairs and attempted to push her, but she was already at the bottom of the stairs and gained her footing and wielded the knife at Defendant Diddy, grazing his abdomen. Hearing the commotion, defendants KK and Jane Doe emerged, and Defendant KK then began administering first aid to Diddy for his injuries caused by plaintiff. Plaintiff tried to make quick dash for the exit, but it was thwarted by Defendant Doe 1. After a period of time, plaintiff was able to abscond from Defendant Doe 1 to the first aid commotion with Defendant Diddy and was able to run down the street. Once plaintiff made it to the street, she began yelling loudly for someone to call the police. I mean, if this wasn't true, this is pretty detailed. Defendant Doe 1 had now caught up with plaintiff, advised plaintiff that he was an undercover cop. To this day, plaintiff is unsure of the truth or falsity of the statement. The same neighbor then again emerged from his residence and asking what was transpiring. Just as plaintiff was attempting to answer, GUN shots began being fired in plaintiff's direction. Plaintiff fled to a car near where the neighbor was also taking cover and lost sight of Defendant Doe 1. Plaintiff then heard a SUV screeching and speeding, leaving the residence. Plaintiff then entered the home of the neighbor, who informed her he had already called the police. Plaintiff informed the neighbor that it was Sean Combs who had attacked her and shot at them, but the neighbor was unaware of who Defendant Diddy was. Shortly thereafter, a sheriff from the Contra Costa Sheriff's Department arrived at the neighbor's home. Plaintiff told the sheriff she had been attacked by Defendant Diddy and others, and that she did not have her clothes, phone, purse, car keys, or cell phone. The sheriff told plaintiff and the neighbor that they had received several noise complaints prior to the neighbor's calls and instructed plaintiff to find a way to get home. The sheriff did not offer to take plaintiff home, nor did he call for emergency services, including an ambulance, nor any offer to take plaintiff to the hospital, nor any offer to help plaintiff recover her clothes or effects from the defendant Shane's residence. Hey, Lori. Lori Loves Life. Thanks for being here. Appreciate you. We're reading the latest complaint made towards Diddy by a girl named Ashley from California. The neighbor offered to let plaintiff sleep on his couch until she could figure out a way to get her possessions and get home, but plaintiff declined and only remained at the neighbor's residence for a short period of time once the sheriff left. Plaintiff then went back to defendant Shane's residence where she found the door open and her clothes were readily accessible in his residence. Defendant Shane then emerged as if nothing had transpired and offered for plaintiff to stay at his residence while she slept it off. Plaintiff asked for her purse and her keys, but defendant Shane told her she shouldn't leave in her condition, and plaintiff, catatonic and in the state of shock and disbelief of the events that transpired, stayed at defendant Shane's home while defendant Shane left the home. Okay, so she stayed there and he left. I don't know. How do you guys feel about that? Later that morning, defendant Shane returned to the residence and woke plaintiff up and finally gave her purse back, cell phone, and keys, and plaintiff left defendant's residence. In a daze, plaintiff returned home and tried to make sense of what had happened to her. On March 26, 2018, plaintiff contacted her primary care doctor and asked for an HIV and STD test in fear of possibly have contracted a disease from her violent attack. Plaintiff tried to continue her life as she felt she wouldn't be believed, and as plaintiff already had told Contra Costa Sheriff's defendant Diddy attacked her to no further avail. Further, plaintiff was under the impression if she did continue to say defendant Diddy's name in relation to the attack, she would not be believed and her family would be in danger. Seemingly mere days, maybe even the day before plaintiff's attack, defendant Shane had miraculously began driving a new car. Plaintiff believes his payment by defendant Diddy for setting up plaintiff to be attacked. A few weeks later, in April 2018, plaintiff, still in pain and reeling from the horrific attack, went to the hospitals as her injuries had not subsided from the attack. Wow. ATS says, I believe it all. You know what? I do too. I mean, this isn't a channel where we victim blame, but like, I mean, this is so detailed. I don't see how. I believe it too. I do. Anyways, let's move on. But, you know, like I said, he still has court, etc. So we'll see. The hospital conducted several tests on plaintiff, including a RAPE kit, ultrasounds, and x-rays. Additionally, plaintiff was given IV fluids to stabilize her vitals as she was in a severe weakened state from being unable to eat and losing a substantial amount of weight since the attack occurred. While at the hospital, plaintiff told members of her treatment team about her horrific attack, and then they contacted Walnut Creek Police. Okay, if there's this many police departments involved, I don't see how this cannot not be true. Now, the details behind that, who knows? But I mean, that's like the second or third police department involved. JoJo says, me three, I totally believe it. Hi, beautiful Augie. I appreciate you for being here. We're reading the latest complaint against Diddy. Okay, moving on. Walnut Creek Police showed up to plaintiff's hospital room and took a statement regarding her assault on March 23rd. Plaintiff had already told Contra Costa sheriffs about her attack and that it was defendant Diddy who orchestrated it on March 23rd, 2018, which was ignored. Plaintiff declined to refer to defendant Diddy again to Walnut Creek Police because she believed she would be ignored by the police just as she was by Contra Costa Sheriff, and or would be further harmed by Diddy if he discovered she named him to police. Plaintiff only told Walnut Creek Police about the attack from defendants Shane 2 and Doe 2. Plaintiff believes her statements made to Walnut Creek Police while at the hospital was captured by police body camera footage. We need that footage. Huh, as true crime. People were like, we need to see it now. Plaintiff further believes her statements made to Contra Costa Sheriff on March 23rd, immediately after the attack, where plaintiff named defendant Diddy directly and by name, was captured by police body camera footage. Wait, oh, okay, I thought I repeated that. Plaintiff also filed a report to the Orinda Police Department on April 17th, 2018, but again was too afraid to name Diddy as one of her assailants. During this report, plaintiff provided her clothing to the police from the night of the assault, but they only retained her underwear. To date, the underwear was never returned to plaintiff, and plaintiff believes no investigation ever commenced. What? Plaintiff sought assistance from therapists in May 2018, one of which tried to have her therapy appointments covered by Victims' Compensation Fund, which was rejected because plaintiff was told no law enforcement agency had opened an active investigation into any of her many reports of the attack. Wow, my heart. I know, terrible. Thereafter, plaintiff asked police for a copy of her report from the Walnut Creek Police Department. On July 19th, 2018, plaintiff was provided a letter from the Walnut Creek Police Department stating that it was unable to furnish this information as it is confidential and not subject to public release, despite plaintiff not being the public and being the victim complainant. This is so sad. 3 police departments didn't take her serious. That is not cool. In March 2024, plaintiff was re-traumatized by all of the events surrounding defendant Diddy, including the several civil complaints filed against him, as well as the raid on defendant Diddy's California and Florida residences. Plaintiff called Contra Costa sheriffs again in hopes of renewing her previous complaint and amending it to ensure Diddy's name was included. Plaintiff received no response from the sheriff. So let's ask the Contra Costa sheriffs. That's something that'll will most definitely be in court, right? In the trial. This is wild. Plaintiff in July 2024 then emailed the chief of the sheriff's office regarding her complaint, lack of investigation, and how she was treated by the initial responding officer. Plaintiff then later received a callback from a detective, but then nothing further. Plaintiff then began seeking legal counsel for her claims, ultimately being referred to undersigned for her representation. Undersigned counsel also attempted to get a copy of the 2018 police report from Contra Costa sheriffs, but was told that they would not provide the report or any other information without a subpoena. Wow. First cause of action, racketeer influence, so RICO. Okay, we know that. I'm gonna skip like the stuff we already know. Defendants, as well as others known and unknown, are persons within the meaning who conducted the affairs of Diddy, SCX abuse and cover-up enterprise through a pattern of racketeering activity in violation of penal code, etc. Okay, so it's talking basically about the RICO charges. This act is an association, in fact, with the meaning of Penal Code 1961, consisting of defendants, including each of their employees and agents, Diddy abuse and cover-up, including but not limited to the defense. I'm just making sure this is like stuff we need to know. Okay, so they're bringing up all these RICO charges. These are just like codes that they're going over. I don't think we need to listen to that. It's just saying that he used his businesses and his name. Oh, okay. That's where it comes. The RICO charges are coming in. They're saying that the plaintiff's efforts to report by concealing and refusing, that all these people basically participated, right? We know that. Defendant has conducted and participated in the affairs of the Diddy abuse and cover-up enterprise through a pattern of racketeering activity described as above, facilitating and financially benefited from forced labor and SCX trafficking in violation of penal code, etc., and instances of transporting women, specifically plaintiff in the instant case, for the purpose of furthering the common purposes of the Diddy abuse and cover-up enterprise, including essay abuse, illicit photography. Oh, so that's like an act now? Videography and other immoral purposes in violation of 18, known as a Mann Act, MANN. I'll have to look more into that. The Diddy SA abuse and cover-up enterprise engaged in and affected interstate commerce, where defendants utilized phone lines to make arrangements for defendant Diddy to further elicit his activities. So they went straight from her into the RICO. They were saying that. That's wild. Each participant had a systemic linkage to each other, participant through personal relationships and employment relationships, function as continuing unit for the purpose of further scheming and other purposes. So they're saying those defendants worked with him in these when because he's being charged for, trafficking. So I believe these same people, 𝐷𝗀 1 and 2 or whatever, they're the same people who helped him facilitate these acts. That's what I'm getting from. And those were the people that all attacked her that night. Defendants, upon information believed, also used the internet and other electronic facilities to carry out the scheme and conceal the ongoing SCX fraudulent activities taking place. The wire transmissions described herein were made in further stance of defendant's scheme and common purpose. Defendant's scheme and the above described racketeering activities amounted to a common course of conduct intended to cause plaintiff and others to hide and conceal defendant Diddy's abuse. So yeah, they were trying to make a point. Each such racketeering activities was related and had similar purposes, involved the same or similar participants and methods of commission, and had similar results affecting similar victims, including plaintiff. Defendants' fraudulent activities are part of their ongoing business and constitute a continuing threat to plaintiff. Okay, so that's what I was trying to get to. Thanks, guys, for being patient. So wrong. Yes. It is horrific. I wonder if Diddy paid someone off. I believe he paid a lot of people off. We know he paid a ton of hotels off too. Augie says him and the rest had way too much power. Diabolical elite. There's many of them out there. And still, I'm surprised he will finally get punished, but pleasantly surprised. Time to clean. Right. I agree very much so with that statement. ETS agrees too. Okay, so wait, am I still on the right page for you guys? Yeah. The pattern of racketeering. I don't think we need to read this stuff. It perpetuated a toxic culture that allowed defendant Diddy's abuse to flourish. He had extensive power and influence on others due to his prominent status as a mogul, his fame and notoriety. Defendant Diddy had command. He had means, access, and influence to provide individuals with a career in the entertainment industry and other industries through his dominant stature in the entertainment industry and connections afforded him due to his fame and notoriety. Defendant Diddy had authority, and defendant Diddy had control. He was at times a mogul and billionaire who cultivated relationships with some of the most influential individuals through his highly sought-after parties and notoriety in the music industry. He also controlled who did what, when, and how within his circle of friends and employees, including defendants KK, Shane, and Doze. If defendants failed to comply with covering up defendants' abuse and attacks and assaults, they would be terminated, blackballed, or find themselves in legal trouble. Diddy had power. Plaintiff attempted to report that it was in fact defendant Diddy who had attacked her, but instead was met with disregard by the Contra Costa Sheriff's Department. Diddy and the Diddy Abuse and Cover-Up Act were designed to manipulate, control, assault, and prevent individuals from coming forward. Defendants KK, Shane, and Doze knowingly benefited from the Diddy Act enterprises as they retained employment benefits and other monetary benefits. Specifically, defendant Shane mysteriously had a brand new car upon information and belief provided to him by the defendant Diddy, and in thanks and appreciation of facilitating the assault. Defendants KK, Shane, and Doze willfully ignored the dangers of defendant Diddy's conduct and pattern of harassment, abuse, and misconduct solely for their own personal economic benefit. Plaintiffs reported to police were ignored. Others who complained about Diddy's egregious behavior were ignored until Cassie Ventura sued defendant Diddy. Since Ms. Ventura's bravery, countless individuals have come forward and filed complaints regarding SA at the hands of Diddy. The chorus of victims and evidence obtained by the U.S. Attorney's Office for the Southern District of New York ultimately led to defendant Diddy being indicted for the RICO violations and trafficking, among other charges. I'm so glad she brings up Cassie. I think Cassie is so awesome and so beautiful. I always really liked her. And that video is brutal. The act enterprise and its members protected Diddy, therefore allowing defendant Diddy to continue with sordid and egregious abuse practices, intimidated witnesses and victims from reporting defendant Diddy's crimes, and interfered with investigations concerning his behavior. Most notably, a video showing defendant attacking Miss Ventura was covered up and sold to him. Me too, ATS. That Me and You song, I think that was a thing for all of us during that time. In the instant case of defendant Diddy was aided and abetted by his network of employees, including defendant KK and defendants Doe 1, his personal bodyguard, who is unknown to plaintiff then and now. So the bodyguard, KK, we're all in on it, and defendant Doe 3, defendant Diddy's driver, who helped him escape and evade capture by police after plaintiff's harrowing escape. Defendant KK, Shane, and Doe's were members of the Diddy Act and benefited from and had knowledge of or should have known a defendant's Diddy proclivities and predatory behavior. Defendants KK, Shane, and Doe's assisted in the defendant Diddy's predatory behavior and proclivities by setting up plaintiff to be attacked by Diddy, as well as assisting in covering up the crime thereafter. Defendants KK, Shane, and Doe's provide defendant Diddy with the means to effectuate his crimes, including carrying the drugs used to disable plaintiff, as well as the means to escape once plaintiff finally regained her faculties. Plaintiff has been injured in her person by reason of these RICO violations. By reason of and as a result of defendant's conduct in furtherance of Diddy Act enterprise and resulting in RICO violations, plaintiff has been injured in her person. As detailed above, plaintiff has suffered direct and severe damage to her professional and personal well-being as a result of the attack and harassment perpetrated by and allowed by defendants. Diddy's attack and violations have caused plaintiff to suffer from severe emotional distress, including developing an eating disorder and extreme weight loss, causing several hospitals. That's sad. Several hospitalization, as well as extensive need for therapy. As a result of defendant's actions, plaintiff has continued to experience fear and anxiety and also sought professional help on numerous occasions since the egregious attack, including several hospitalizations, visits to her personal physician and therapist. Diddy's assault and violations have caused plaintiff to be fearful, distressed, anxious, degraded, and depressed. Plaintiff has gained a global distrust for individuals. If not but for defendant Diddy's direct action and the atmosphere cultivated by him and the defendants who were members of the enterprise, plaintiff would not have developed several issues that have severely impacted her life and livelihood. Her issues and her overall health has been exacerbated by ongoing trauma of not being believed. The damage to her person is incalculable. Plaintiff has experienced years of anxiety and depression since the violent attack that occurred in 2018. Her anxiety and depression were compounded by the lack of care and complete disregard of reports to law enforcement. Even when plaintiff was brave enough to name defendant Diddy to the police when called immediately after the incident, she was dismissed and treated as if she was lying due to the fame and overall public support of Diddy at the time, which speaks to the widespread influence defendant Diddy had over the general public at large. Plaintiff has struggled with her inability to reconcile her horrible experience with Diddy and other members of the enterprise and their outward failure to protect women, as members included women. At relevant times, all defendants were aware of the essential nature and scope of the enterprise and intended to participate in it. So the second cause of action is violation. Okay, so we might be skipping some of this. It's just basically talking how they all agreed to commit racketeering offense Defendant knew the general status of conspiracy was to enable and cover up defendant Diddy's decade worth of attacks. Each enterprise member knew the general status of the conspiracy was to enable and cover up Diddy's decades of attacks. Each defendant knew the conspiracy extended beyond their individual role. Specifically, an effort to enable, further, and protect, aid, secrete, and cover up each of defendant Diddy's attacks, defendant Diddy pattern and practices, and abuse, defendant Diddy's battery against plaintiff Diddy. Defendant agreed to engage of the predicate offenses identified above. Defendants knew their predicate acts were part of a pattern of the racketeering activity and agreed to the commission of those acts to the further schemes described above. Third action of cause, SEX battery. Diddy exploited his position of authority to intimidate, overwhelm, and subdue plaintiff with the assistance of defendants Shane, KK, and Does 1 through 2. Any objections to his conduct would be met with retaliation. Defendant Diddy abused his position of power and authority over plaintiff, who was in no position to reject his attack due to her being physically outnumbered, unable to vacate the premises, and having on her clothes, purse, cell phone keys, and keys hidden from her. Defendant Diddy, Shane, and Does 1 through 2, battery on plaintiff caused physical injury, severe mental and emotional distress, pain and suffering, mental anguish, and loss of enjoyment of life. Defendant's unlawful actions were intentional, done with malice, and showed a deliberate, willful, reckless indifference for plaintiff's rights. Okay, so then the fourth cause of action, we're kind of just going over what is in this essay. So we already know about all of that. We read it earlier. Drugging, violence, duress, menace, or fear of immediate unlawful bodily injury to plaintiff. Defendant's actions caused plaintiff to fear retaliation in the future, and there was a reasonable possibility that defendants, specifically defendant Diddy, could execute a threat of retaliation. Okay, we're gonna skip through these penal code stuff again. Sorry guys, I only got through half of this. I didn't read all of it because it's really long, but I mean, you guys get it. The fifth charge is harassment, SEX harassment. Made advances, solicitations, requests, demands, as well as engage in other verbal, visual, or physical conduct of a SEX nature or of a hostile nature based on plaintiff's gender, all of which were unwelcome and pervasive or severe. Defendant Diddy specifically used his authority to coerce and exploit defendant Shane into luring plaintiff to his home so that defendant Diddy could physically, psychologically, and emotionally, through force, manipulation, emotional abuse, intimidation, and retaliation, abuse the plaintiff. These acts were done for Diddy's gratification. I've been watching and listening. Dang, this is a lot. Hey, Paul, thanks for being here. Karma finally found Did's address. I hope she'll have fun with him. I know. They are all so brave. They very much are. Okay, let me see. The sixth charge is battery. So I'll skip this part as we kind of already know. Diddy exploited his position to subdue plaintiff. Used his position of power and influence over plaintiff, who was in no position to reject his advances. Seventh, assault. There's so much that he is being accused of. This is just stating how it caused physical injury, severe and mental and emotional distress, pain and suffering. How it was done in malice, and she wants, compensatory damages for that. Negligence is the next charge. She's saying, claiming her pain and suffering their losses and their permanent or continuing, and plaintiff will suffer losses in the future. The ninth cause of action, negligent failure to warn. Plaintiffs incorporate by reference and reallege each of the proceedings to be true. Defendant's conduct created a risk of physical or emotional harm. Despite the knowledge of danger in the participating of the enterprise, defendants did not alert plaintiff to the risk of the assault. In fact, defendants facilitated and assisted Diddy. We know that with his deviant activities and despicable behavior. Defendant Shane specifically represented to plaintiff that she would be safe while a guest in his home and would be free risk of attack. Defendants, specifically defendant Shane, had reason to know that plaintiff would be unaware of the risk of attack, harassment, kidnapping, and physical attack, RAPE, and other attacks by being a guest in the defendant's home or his association with defendant Diddy and the enterprise. A warning to plaintiff by any defendant that she was at risk of sexual assault, harassment, kidnapping, and other attacks by defendant or any other defendant would have reduced the risk of harm to plaintiff, who could have taken safety precautions and avoided being a guest in defendant Shane's home and completely avoided the attack. As legal and direct result of the aforementioned conduct, the omission of defendant's plaintiff was attacked, harassed, kidnapped, etc., and robbed of her dignity and her personal safety. The 10th cause of action is negligent supervision and retention. Defendants 𝐂𝐤𝐤𝐽 1 and 3 and Jane Doe were employed by Diddy. 1, 3, and Jane Doe were unfit or incompetent and posed a particular risk of harassing, attacking, and abusing plaintiff mentally. Diddy knew or should have known not only that the defendants 𝐂𝐤𝐤𝐽 1 and 3, Jane Doe, were unfit or incompetent and posed a particular risk of harassing, but also that this unfitness created a particular risk. Defendant 𝐂𝐤𝐤𝐽 1 and 3, Jane Doe's unfitness harmed plaintiff. Diddy knew or should have known that defendant Doe 1 had previously engaged and was continuing to engage in this conduct for his own gratification. He is a true monster. Defendant Diddy knew or should have known that it was foreseeable that defendant Doe was engaging or would engage in these illicit activities with the plaintiff under the cloak of authority, confidence, and trust bestowed upon him through defendant Diddy. At no time during the alleged period did defendant Diddy have a place in reasonable system or procedure to investigate, supervise, and monitor defendant Doe 1 to prevent attack, nor did he implement a system of procedure to oversee and monitor conduct towards individuals they encountered. Even though Diddy knew or should have known of these illicit activities by himself and defendant Doe 1, he failed to reasonably care in supervising defendant Doe 1 and did nothing to investigate, supervise, or monitor him. Well, duh, right? They work for him. 11th cause, emotional distress. So I'm going to kind of skip that part because we've gone over, like, that she's had to deal with that a lot, which is unfortunate. The 12th cause of action is negligence on emotional distress. 13 is unjust enrichment. This is a lot. I don't know what unjust, we'll probably have to read some of this. Defendants appreciate and have knowledge of such benefits. Used principles of equity and good conscience. Defendants should not be permitted to retain the profit they received and retained at plaintiff's expense while refusing to provide compensation for the injuries suffered by plaintiffs as a result of their unlawful conduct, including their failure to guard against, educate as to, or otherwise failure to prevent such injuries inflicted on plaintiff. So there's what that means. So that they shouldn't get paid, or that they need to be held responsible, right, to pay for her injuries. They should not be permitted to retain the profit they retained at plaintiff's expense. Fourteenth cause of action, aiding and abetting. Kind of going to skip through this. I'm just kind of hitting the main parts. It's like Diddy and his group were called like an enterprise, right? For the RICO charges. Through aforementioned acts, defendant caused plaintiff an imminent apprehension of harmful or offensive contact with an intimate part of plaintiff's body, and contact with plaintiff resulted in substantial factor in causing harm. She suffered economic injury. And then she's ready to prove that in trial. It says, plaintiff has suffered economic injury. Plaintiff's general, special, and consequential damages are an amount to be proven at trial. So there we go. There we go. We're gonna hear more about this surely. In May, but who knows, that court date, that trial might be pushed back with all of these charges. Okay, so this just says that she's seeking, compensatory damages. Here, plaintiff was attacked by defendants Diddy, Shane, and Does 1 and 2 at defendant Shane's residence. Plaintiff was legally on the premises as a guest and invitee of David Shane. Defendant Shane, through renting the premises, had dominion and control over the premises where plaintiff was harmed. Defendant Diddy had dominion and control over the actions of defendant Shane, Does 1 and 3, and failed to step in. So as the owner of the property, defendant Shane had a duty to protect plaintiff. And defendants Diddy, Does 1 and 2 breached his duty when he failed to stop them from attacking plaintiff. So 15th charge here. Trafficking in Victims Protection Act. Okay, we're gonna skip this part. It's basically defendants had actual knowledge that they were perpetrating, facilitating defendant Diddy's trafficking abuse to recruit, solicit, entice, coerce, harbor, and transport, obtain, and provide plaintiff into non-consensual acts through the means of force. By taking concrete steps alleged in the complaint, defendants knowingly participated in the trafficking and furthered the Diddy enterprise. Okay, I'm going to skip through like some of this basic stuff. What does that mean? What does what mean? Oh, the charge that I just read? Is that what you're asking what that means? Defendants knew that its active engagement would lead to and cause coercive trafficking. Defendant's affirmative conduct was committed knowing and in reckless disregard of the facts. The defendant Diddy would use his means and influence to force and intimidate plaintiff into non-consensual acts. This is talking about how she's still looking for, serious harm, including without limitation to physical and psychological issues. Defendant's criminal conduct in perpetrating 𝗵𝗶𝐴 violations was outrageous and intentional because it was in deliberate furtherance of widespread and dangerous trafficking organization. Defendant's criminal conduct was also evinced at a high degree of moral turpitude and demonstrated such wanton dishonesty as to imply a criminal indifference to civil obligations. Defendant's criminal conduct was directed specifically at plaintiff, who was the victim. Defendant's outrageous and intentional conduct in this case is part of a pattern and practice of profiting by undertaking illegal high-risk, high-reward actions. By virtue of knowing and intentional violations, defendants are liable to plaintiff. 16th cause of action, aiding, abetting, and inducing trafficking venture in violation of the Trafficking Protection Act. Okay, so we're going to skip that. There's a lot of like codes here, and it's talking about the trafficking charges. Defendants had actual knowledge they were aiding and abetting and inducing Diddy and his co-conspirators' crimes to recruit, solicit, entice, coerce into non-consensual acts. Okay, non-consensual acts. We know what that means. Okay, so defendant's outrageous and intentional conduct in this case is part of the pattern by profiting by undertaking illegal high risk and high word. We already read that part too, right? 17th cause of action, knowing beneficiary in trafficking venture in violation of the Trafficking Victims Protection Act. So this is all has to do with the RICO charges. Defendants knowingly and intentionally benefited financially by receiving things of value from participating in and supporting and facilitating in these illicit crimes. It's talking about how they took many steps to hide his crimes, obviously, and participate. Defendants knew or should have known that they were feeding defendant Diddy's sexual deviancy. Upon information and belief, defendants received financial benefits from defendant Diddy and his crimes, and most notably a new car for defendant 𝐁𝐻. 18th cause of action, obstruction of enforcement of the Trafficking Victim Protection Act. Okay, so those are a bunch of penal codes as well. Okay, wait, I have to read this part because I saw the name J.E. brought up. Upon information and belief, defendant Diddy has a well-documented history of criminal investigations. Defendants were on notice of defendant Diddy's proclivity to criminal activity. They knew or should have known that defendants Diddy and enterprise operation would or could result in criminal investigation by state and federal prosecutors for violating, among other laws, the 𝐡𝐵PA. Defendants should have taken a cue from the federal prosecutor's arrest and prosecution of Jeffrey E. The U.S. Attorney's Office for New York indicted �Epstein and unnamed associates for violating the same order. Later, the same office indicted his co-conspirator, Ghislaine Maxwell, for conspiracy to entice minor victims to travel and be abused by Epstein. All named defendants in this matter engaged in the same activities as Mr. E and Maxwell. In fact, defendants may have done worse. Wow. They're literally comparing him to J.E. here. Okay, so it's just basically saying that, one example of how defendants obstructed, attempted to obstruct, interfered with, and prevented state and federal governments. Defendants provided resources to defendant like security victims, DRUGS, getaway driver, and false alibis so that the acts would escape the detection of state and federal law and prosecuting agencies. Upon information and belief, defendants' obstruction and attempted obstruction, interference with prevention of the act were all done intentionally and knowingly. For example, defendants knew that defendant Diddy was high risk, specifically high risk to violate the 𝐡𝐵PA through continuing trafficking activities due to his proximity to criminal activity as far as back as 1991. Upon information and belief, defendants were aware and participated and engaged in intimidation, bribery to escape criminal liability. Defendants concealed information from the federal government in an intention to obstruct and in many ways interfere. Okay, so it's going over and talking about all the violations of the RICO charges. We're getting to the end, only a few more pages. Under information and belief, defendants' criminal conduct in obstructing enforcement was outrageous and intentional because it was deliberate furtherance of widespread and dangerous trafficking. 19th cause of action is false imprisonment. False imprisonment. Okay, let's read that part. We only have like 1 or 2 more pages to go. Oh, yeah, because defendants intentionally detained and prevented plaintiff from leaving the premises, therefore imprisoning plaintiff, acting in deliberate malice and purpose of attacking plaintiff. Defendants imprisoned plaintiff without just or reasonable cause, without lawful privilege, without plaintiff's consent, and or without probable cause for appreciable amount of time, and therefore deprived plaintiff of her personal civil liberties. She was invited there as a guest. Plaintiff was under the impression it was safe. Defendants forced plaintiff against her will and over her protest with threats and physical violence, and then forced plaintiff to engage. Plaintiff was not released from her imprisonment until she made her harrowing escape as enumerated in the above complaint. As a legal result, defendant's action, plaintiff was physically, mentally, and emotionally injured, all to an extent and an amount subject to prove at trial. As proximate result of the acts of the defendant's, plaintiff has suffered great damage to her person, reputation, and embarrassment. All of these injuries caused to plaintiff to suffer physical and severe mental pain. Oh, so it's talking about how medical professionals will be, I guess, like witnesses. Hi, beautiful Stella. All right, you guys, we got to the end of it. And it says request for relief. Dated October 15th. Hi, Esther and beautiful Stella. Thanks for being here. Were they friends? Yeah, employees, friends. I don't know. We'll find out who the rest of them were, but we know the bodyguard, the driver, KK, who is Christine. I can't remember her last name, but she obviously worked for him. So anyways, we got through it. Yay, we got through another document. I know that one was long. It was like 62 pages. So thank you guys for hanging out and listening to that. I will be back later to do more true crime. I just wanted, because I've been reading all of the Diddy legal documents, and I'm gonna cover Cassie's too. I want to go over that one. So I know sometimes they get a little boring, but I really like covering them. Yes, Stella, go back to the beginning and just listen. Thank you for stopping by though, and I appreciate you guys. Make sure you hit the like, and I will see you guys maybe in a few hours with another true crime live. So again, I appreciate you guys for being here. Yes, click the like button and share and subscribe, and I will see you guys shortly. Thanks guys for being here.